Hi everyone, this is Rajiv from the law offices of Rajiv S. Khanna, PCimmigration.com. Today is June 20th, 2013. This is a community conference call, not intended to create attorney-client relationship, and the information is for community purposes only. That said, let me get started as usual, first with answering the questions that have already been posted, and then time permitting, we'll do follow-ups, and after that, time permitting, we will do new questions that have not been posted or followed up. Okay? I think we'll have enough time for new questions. First question that has been posted is from Jake Ham, denied I-485 and I-130. They say their I-485 and I-130 was denied this week, and they are given an option to reopen, reconsider, or to appeal the I-130. They came in as an F1 student out of status due to a sick sponsor that was hospitalized, married to a US citizen at birth. So you are not married at birth, but you are married to a US citizen who was born here in the United States. Well, there's no reason to panic. Don't panic. The good news is, I'm not sure why your I-130 was denied, but you can always refile it. So you can file a new I-130, I-485 since you are married to a US citizen. Don't travel outside USA until your green card comes through. Just make sure you talk with somebody before you do that, traveling. But this matter is not that complicated. It's simple enough. So you just refile the I-485 and I-130. And if there's a ground for filing a motion to reopen type of thing, somebody needs to take a look at. I don't know the facts of the case, but you can always do that as well. So like I said, no need to panic. Next question is from Finally 2013. Impact of filing AC-21 when I-485 is already pre-adjudicated. How long does it take? Well, the question here is, I've got my I-485 pre-adjudicated. For those of you who don't understand what pre-adjudication is, that means the case become ripe for adjudication. One of the USCIS officers actually reviewed the case, and then the priority date slipped back, so the case was put on shelf but marked as pre-adjudicated, which means it's pretty much decided. Now the question is, if we file an AC-21 now, are we going to have a problem of delay? And the answer is, it probably is going to take you some extra time. Is it gonna take a year extra? No, I don't think so. A few weeks, maybe a few months, but it's difficult for me to predict. There are so many things that can be variables here. I cannot really tell you down to the last day or even to the last week how long it can take. Okay, so this is definitely a question of strategy. You've got to get together with your lawyers, see what they think is the best way to approach this. I'm looking at the rest of your question. I-140 approved in 2012. I-485 is back, pending in March 2012. I-485 was pre-adjudicated. InfoPass officer confirmed in Jan 2013. Your new job requires bachelor's plus 8. Green card was filed with master's plus 1. So the suggestion that you want from me is take a new job and file AC-21. Take a new job and don't file AC-21. Stay with company B and change jobs after 6 months after getting green card. Well, first of all, the last part you've got to be careful with. If you have a preconceived intention of leaving even after 6 months, that's not such a good thing. Green card is given for those jobs for which you have an indefinite intention to be employed. Okay. And if you change your mind 3 months, 6 months, 4 months, 5 months down the line, that's okay. But you must have the intention to stay on indefinitely. What is better for you? Take a new job, file AC-21, or don't file AC-21. All these are things that your lawyers should sit with you. They should look over the new job's profile, see how same or similar they are. Personally, I think even bachelor's plus 8, you could make an argument for it that it's the same thing as, or similar thing as master's plus 1 year. So I am okay even with this job profile, but these things are so difficult to predict in vacuum. Somebody has to look at your paperwork and decide precisely how best to approach your situation. But you do have a lot of options. That's the good news. Give me 1 second. Let me go on. Did I miss something? Yeah, okay, I think I've answered all your questions. I go on to the next one, Bhati. Now, these are some interesting questions. I was actually going to do a separate a recording for this. It's a very interesting set of questions. How to receive my I-140 copy? Because it happens many times that you've got your I-140 approved and the old employer or the employer that you want to leave and go to somebody else will not give you a copy of your paperwork. Why is it important? Well, two reasons. One is people want to carry forward the priority date. So they want to have at least a copy of the I-140 approval. Second reason is that if you want to do, in this case this is not applicable, but sometimes when you have a 485 filed also and you want to do an AC-21, you need to know what the job looked like, because AC-21 says the job that you are leaving and the job that you are going to should be substantially similar or same. If you don't have a copy of the job description, the ETA 9089 labor certification, I-140, etc., you may not even know what the job description was. So it becomes important for two reasons. First reason about the priority date transfer, the good news is even if you don't have a copy of the I-140 approval, you still should not have a problem, because USCIS does a scan of their system periodically and automatically assign you the priority date to which you are entitled. That's one good thing they've done over the last year or so. So you should not need a give me 1 second, just making sure we're in the right conference line. For a moment there I had a little doubt. The conference number has changed. We've gone to 8394, reserving 8395 for clients. So in any case, yeah, it looks like we are all here. I'm looking at the people logged in. So obviously we have not made any mistakes. Okay, so getting a copy of the I-140 for carrying forward the priority date may not be important, but it is important for doing an AC-21. How do I get a copy? There are two approaches to this. One is to contact the lawyer. Many states, including Virginia, require that unless the individual gives some kind of a waiver in writing, they are entitled to enough information to protect themselves. Lawyers have to submit that information. In fact, I had a case in New York, and luckily the lawyer there, initially first they responded they were not going to give us a copy of the paperwork. I was going to take some action against them, but fortunately they changed their mind and the employer did give us a copy. But you know, laws do, the state bars have rules about what kind of information the lawyers must provide you to protect you. Okay, that's one option, lawyers. Second option is to file Freedom of Information Act request. We have been quite successful in that, and typically when you file a Freedom of Information Act request, the form is on USCIS website. I think it's called I-639, Freedom of Information Act, FOIA, F-O-I-A. And that form should be filed and ask for all immigration related documentation that the government has. You should be able to get a copy of pretty much everything. Okay. What are my options if I want to switch employers while my request for an I-140 copy is pending? Nothing is stopping you from doing that. We have even done H1 extensions without even a copy of the I-140 approval. Can I change employers without a copy of the I-140? Talk to your lawyers. Talk to the lawyers who are going to do an H1, because this is an H1 related issue. Can they do an H1 without a copy of the I-140 approval? In my view, yes, we've done it. Okay. 5, would my current employer know that I've applied for a copy of my I-140? I don't see why they would know. USCIS does not notify them, no. Can I extend my H1B with a different employer using a copy of the I-140? Yes, you can. Will your office assist me in applying for an I-140 copy? If you're asking us, can we help you file the Freedom of Information Act request form? Definitely. Definitely, no problem at all. Next question is from Amti. Can I re-enter US with a valid I-797 and no stamp? What you basically mean is a valid I-94, not 797. That's called automatic visa revalidation. Automatic visa revalidation. Except for, it used to be 8 countries, I think there are 4 or 5 countries that are not allowed to do AVRs. I think those countries are probably Iran, probably Libya, there may be a couple more. Some countries are not allowed to do AVR, but citizens of most countries can do AVR. And the idea is, if you have an unexpired I-94 and you are maintaining status, so for example, typical example, let's look at your case. I-140 is approved, came on F1 visa. Yeah, so you came on F1, you got your H1B. As long as you got an I-94 with an H1B, that means you had a change of status, you can actually travel outside USA to Canada or to any of the contiguous territories like Mexico. You can, if your trip is less than 30 days, don't surrender your I-94. You can re-enter USA without a visa using the I-94 that was approved along with your H1. So what did you do? You changed status from F1 to H1 within the United States. You do not have an H1B stamp. You want to travel to Canada for less than 30 days and back. As long as you don't apply for H1B visa and get denied in Canada, you are allowed to travel to Canada and re-enter just with your I-94. But you cannot apply for a visa. Just keep that in mind. Okay. See, you are saying my question is I will get Canada visa based on that I'm going to get my H1B stamp. Those people, if they are denied H1B visa stamp in Canada, cannot use AVR to re-enter. Now, in the past, CBP, the people at the border, they may not know the law, they may have let you through, but if they see the stamp of denial, they should not let you through on AVR. Your only option at that point of time would be to fly back to your home country for visa stamping. So AVR is available except to people from a few countries, 4 or 5. AVR does not, however, apply to those cases where people are going to go get their visa stamping and then they get denied from. If the visa is allowed, sure, then you can re-enter on the visa. AVR is a non-issue. But if the visa is denied, you cannot use AVR. New 400 says, my 70 years old aunt left the USA with 10-year permanent residency card about 3 years to take care of my brother. After 1 year, the green card is gone. Okay. Where do I start? Look at SB1, SAM Blue 1, SB1, also called Returning Resident Permit. This is an application you make through the US consulate. They will want to be assured that you tried your level best, or your aunt tried your level best to come back, but because of circumstances beyond her control, she went way over the time. It's a fairly, it's not easy to get this returning resident permit. Consulate does want to make sure that you tried your best, and even then you couldn't make it. Okay, so look at SB1, SAM, B as in blue, SB1 visa or returning resident permit. Ankur says that his employer, which is a large company, 50,000 employee company, they have come up with this new policy. So their salary in the H1 was 70,000. They dropped the salary down to 40,000 and they say we are going to pay you overtime. And if for some reason the overtime is not 70,000, it doesn't become 70,000, they'll pay you that extra money anyway. That's what it sounds like to me. So there is some hanky-panky going on here. It doesn't make sense. It looks like there is some fraud involved here. And I think this company you should report them. If they are, doing this kind of, we need to protect the system against people like this. If they are taking advantage of, personally, if a client came to me and said, we are going to do a system where we are going to try to get around US laws, I would absolutely refuse to cooperate. There is no way I would give advice to somebody who wants to break laws like this. to me it sounds like there is something very weird going on, and they are trying to cut hours out of your wages. And I think that they are in violation of H1 laws as well. Okay, I'll give you an example. One of the requirements of H1s is that the salary must be paid in equal installments. So if they are paying you $3,000 in 1 month, and 9,000 in the next month and 5,000 again, it's kind of to me it sounds like they're breaking the law, even the Department of Labor laws. You should look into filing a complaint with both the Wage and Hour Division of the U.S. Department of Labor as well as the California, what do they call them? I forgot the name, the local Department of Labor. Is it called California Economic Development? I forgot. We used to deal with them so much. Trying to remember their name. But basically the local Department of Labor in California. Okay. So my employer, these are your questions. My employer filed my perm and showed 70,000 as base salary. Now they have reduced the base salary to 40,000. Does it have any impact on green card process? You see, it may not, because green card is a future job. Okay, but an employer who's trying to get around U.S. laws, they could have a lot of problems. I mean, these guys could be criminally prosecuted. They should be criminally prosecuted. I'm very strong in my opinion about this. There is no reason people should be allowed, especially these large companies, they're trying to take advantage of U.S. laws. That's just not right. So, generally speaking, there is no direct effect on your perm application, but indirectly the company could get into trouble, and if they do get into trouble, then all their green card filings can also be called into question. That are these really bona fide good faith jobs. For visa stamping purposes, would reduction in base salary have an impact? Yes, it can, because that is directly relevant to H1 visa granting. Okay, it can. Would reduction in base salary, even though the pay stubs show true up payment of X number, have an impact at port of entry again? If they start questioning this arrangement, which to me it sounds like it's questionable, it can be a problem. 4, are there any areas of immigration that would have impact while I'm on H1B? What can I do? You should definitely look into filing a complaint, Ankur, because to me it looks like you will have whistleblower protection. I mean, it may not be a perfect protection, but it does protect you, and personally I think this should be reported. Earlier, my job title was system analyst in perm application. Now job title is testing analyst internally. Does it have any impact? Again, green card is for a future job. It can be totally different from what you're doing now. As long as everything is being done in good faith, to me it looks doubtful that it is. You should be okay. All right. So about the Hatch-Schumer amendments, I have not looked. There's so many amendments lined up. I've stopped looking at them until the laws become a little bit more crystallized, and we can actually start looking at everything that they've changed. But just going by the language that you've given, this is, your question is, does the above named rule, and you've given the language or the statute, extend the benefit of EAD to H4 holders, etc., etc.? Well, the language says this: upon the request of the Secretary of State, the Secretary of Homeland Security may suspend employment authorization. What they mean is, the previous rule before Hatch Amendment was introduced was this: we will give H4 visa holders work authorization only if the country where they come from has similar reciprocity for dependents of US workers in that country. Now they are saying no. We'll give you EADs, but if the State Department requests that this country's EADs should be suspended because they do not give reciprocity, then we will suspend it. In other words, instead of starting with the starting point being, we're not giving you any EADs, Mr. and Mrs. H4, until your country can demonstrate that they have similar correspondence for US citizens or US workers, we start from a different point. We'll give you EADs, but then we can suspend them if your country doesn't have the same reciprocity. It has a certain advantage that you can actually, if you come from, for example, Pakistan or India, you can actually talk to your government, get together and say, give similar reciprocity to US workers. That way, you will not have the issue of suspension if this becomes law. I hope that made it clear. Next question is allowing I-485 to be filed once I-140 is approved and priority date is not current. Question: assuming this bill is passed, does that mean for all the applications for whom I-140 is approved, they can immediately file I-485 and within 6 months be eligible for EAD? Give me 1 second. Let me review the amendment. There's no 6-month rule. It seems like you will get your EAD right away. If this becomes law, from what I can see, maybe I'm missing something, there's no 6-month rule here. It says any alien and dependent who has filed a petition for immigrant status, I-140 that means, may concurrently or at any time thereafter file adjustment of status if such petition is pending or has been approved, regardless whether the priority date is current or not. Immigrant visas, immigrant. So yeah, there is no 6-month limit. What it means is, if this becomes law, this language gets passed, if you have already filed I-140, you can immediately file 485. We don't care if the priority date is current. What is the advantage? You get EAD, your dependents get EAD, and I suspect AC-21 is available. That's a very nice change. Okay. Would it allow applicants to change jobs after 6 months of filing I-485? It looks to me, yes. It looks to me like you would. Okay. But I would, again, I will be cautious in this. Let me see how this law develops. Let us see also how USCIS interprets it. To me, in the language of the law appears to be pretty clear. You would be entitled to AC-21 benefits, which means changing jobs. Okay. Next question. Jushan wants to know, my H-1B petition is not selected in lottery. OPT is ending. What do I do? How can I stay? Well, people go back to school or they do a STEM extension of 17 months. Those are the two options that most people are taking. Okay. Are there any other visas available to you? I don't know. That depends upon your situation. Next question is Vivian Iber, it looks like. What waiver do I need? Got deported on misrepresentation. If I complete my 5-year ban, there is no 5-year ban. Misrepresentation is a permanent bar. Unless you are so far back in time that at that time there was 5-year bar. But currently, for the last many years, if there is misrepresentation, that's a permanent bar. If the misrepresentation is for immigration benefits, that's a permanent bar. There is no waiver. The only waiver there is something called 212D, D as in doctor. 212D waiver only allows you visits for a particular purpose for a particular period of time. That's it. It's a permanent bar. Again, there is one waiver available for this permanent bar. If your, I think it's US citizen, immigrant, spouse or child, yes, spouse or child would be subject to extreme and exceptional hardship, which is not easy to prove, then you can get a waiver. But your spouse or your child must be a US citizen or green card holder. Okay. Purple girl is stuck in India, lived in USA for 13 years, 485 pending, priority date July 2003, had to quit job, travel to India for family reasons. AP and EAD expired, which means your 485 is gone. I would like to come back to US to resume my green card process. Do I have any options to come back? No, you do not. Other than H1 or L1, you would have a very hard time getting any other kind of visa, in my opinion. Okay, because you have exhibited immigrant intent, and once you've done that, coming back on tourist visas or any other visa is very difficult. Next question is from JTRs. They have children aged 12 and 14 who've got their US passports. Mother was, through father who was American citizen, mother was born in Venezuela. Okay, we currently live in Venezuela, and to renew US passports of children, the American embassy requires citizenship certificates. I think it should be N600. I think it should be N600. I'm not sure how 600K would apply. I think it's N600. You can double check. You can send an email to the US consulate closest to you in Venezuela. They usually respond, excuse me. They usually respond to emails quite expeditiously. I'm pleased to see that. They may not always give you full information, but at least they try. I think N600 should work. Dual citizenship, one passport expired. I have two citizenships, Italian and Venezuelan. Okay. I have a green card since 2008. Always used my Venezuelan passport. Now it will expire in September, and it's impossible to renew. The Italian passport is okay, I just renewed it. Since my Venezuelan passport is expired, can I leave USA with my Italian passport? Leaving is not a problem, coming is the issue. Well, you haven't said one thing. You said you used your Venezuelan passport, but for green card, did you give your country of citizenship as Venezuela, Italy, or both? The form usually allows you only one. What I would do if I were you, I would contact CBP, Customs and Border Protection. Go to cbp.gov. They have a frequently asked questions online, which is quite good. You can also contact them. They actually will talk with you. You can even go to one of their offices and try to speak with an officer. Explain your situation and see what needs to be done. There is no doubt in my mind that you will ultimately be allowed in. Okay. The question is only to make it easier. So contact CBP, find out what they say, and please share with us. You can send me an email to help@immigration.com, HELP@immigration.com. I'll be most interested in saying what they tell you. Okay. Most interested in knowing what they tell you. Next question is amp shot watts. This is a very strange story, and I'm not quite sure what to tell you. It's a little bit beyond my expertise, because this is a question of customs enforcement more than immigration in some ways, and there is a part of immigration as well. So, wife-to-be tried to come from Ghana, Africa, and brought some gold, but she was apprehended at JFK, and customs had her in custody at JFK for over 1 year between 2010 and 2011. So there's a whole lot of story that goes with it. In any case, she's second time in custody when she went to claim her gold. Customs never mentioned about $6,000, which is what she's supposed to pay. I guess it must be some kind of a bond. I'm not really clear about your situation. She wants to return home and take her gold with her. The question is, can she take her gold? I don't know. So that's really a question of customs enforcement. I have no idea. I don't work in that area of the law. The part that I can kind of help you deal with is, if she is deported, is she going to be able to come back? Well, that depends. I don't know what she has been charged with. If it is a crime, coming back can be difficult. If it is just a civil violation, it might be a lot easier. I think you need to get yourself a lawyer who does deportations. We don't deal with cases like this, but this whole situation sounds very, very odd. So my advice to you, as best as I can give it, is get yourself a lawyer who does deportations and exclusions. And if you cannot afford a lawyer, there are plenty of free agencies, and lists are usually maintained by immigration courts who might be able to help you understand your situation. Okay? Immigration courts maintain volunteer agencies lists. Hardik is a research scholar in cardiology on J1 visa with 2 years home residency requirement. So you're not a physician who's doing residency. You are a researcher. Okay. Got married to a US citizen, wants to apply for an LPR. What is the best way to get a J1 waiver? I hope you are on the phone, Hardik, because I'm not sure. I hope that yours is not a clinical J1, because if it is, then you've got certain limited options that you can try, and no objection is not by itself going to help you. Okay. Usually if you're married to a US citizen, extreme and exceptional hardship to the US citizen can be a ground for getting a waiver of the home residency requirement, but these grounds are difficult. They really do require more than ordinary hardship. If you're a clinical J1, then underserved area, Veterans Administration, federally approved labs, similar types of waivers, Department of Defense waiver, these kind of waivers are what people are using mostly. Okay. Statement of reason for getting the waiver, I don't think the no objection to return to India, the NORI is going to help you by itself if you are a clinical person. If you are non-clinical, you are sure about that, typically, I can't tell you from the Indian angle what they are looking for, but from the American angle, when you provide a statement to the State Department, they just want to make sure that you did not have a preconceived intention to convert from J1 to green card or any other status when you came from India. Okay, so basically, typically there can be situations where you came and you started your research scholarship in cardiology, and then you realized, hey, if I go to India, I will not be able to use this knowledge because we either don't have these kind of operational tools, or our state of implementation of this knowledge is still very primordial, things like that. And then you realized, I cannot really go back. If I go back, all this training will go to waste. That's one example. Please don't make up things, whatever the truth is, but that's what they're looking for. Changing job using EAD to a position that needs more years of experience. So the question is, I'm on H1B, I-140 is approved. Green card is in EB2 category, senior analyst position, requires 5 years. Can I join a new company which needs 8 to 13 years experience, although the nature of the job is the same? Krishna, the problem I have with this question is, I don't know the context. If you want to start a totally new green card, you can have any job you want. And if the job requires more experience, that's fine, as long as you have the experience. If you are asking in the context of AC-21, then we have to look at both jobs, compare them. As long as the jobs are substantially similar, you should be okay. DH Lunar says, my wife became naturalized US citizen about a month ago, filed for mom, filed for dad. So basically NBC has a satellite office in Overland Park, Kansas, and NBC is sending work to field offices. There is a work redistribution. I know that. As to what extent, I see those postings all the time from USCIS. I really haven't paid attention to it, but I know that there's work redistribution going on. Processing time has been an issue, and this issue has been brought up with USCIS. Your best bet is to just call USCIS customer service. It's going to take you a long time to get through, but once you get through, you can ask them these two questions: processing time as well as work redistribution. They should be able to help you out. Okay, citizen sibling files backlog. So I heard, this is what Mr. Mansoor is saying, or Ms. Mansoor is saying, I heard if Immigration Bill 2013 passes, the processing time will be reduced to 18 months. I don't think so. From what I remember reading of this provision, it didn't say that the processing time of brother sponsoring brother would come down to 18 months. What it said was this: we are removing this category. However, everybody will have 18 months grace period to file an application. After 18 months, these applications will no longer be available. Okay, so I do not believe that is the correct situation. But if you guys think I have it wrong, feel free to share it with me. I'll be happy to correct what I just said. But from what I remember reading this bill a few weeks ago, it just said that we'll have an 18-month grace period. I think I have a video on this. You can look at our YouTube channel as well as it's in the audio video documents, audio video material on our immigration.com website. So I have a video on this when I discussed the law. I'm pretty sure I covered this point as well. I don't recall what the law said. Can one use their leftover H1, H4 time for a potential employer willing to sponsor after change of status? I'm not sure what the context is. This is a totally different question. But first of all, H1 and H4 times are different. It used to be that H4 time was counted towards H1, no longer. So first thing you need to understand is H4 time does not go towards H1. Second, if H1 time is left, of course you can use it. Third question is, I have a master's degree that comes under the list provided by STEM, and I have taught in school in US for 4 years. Am I eligible to file EB2? Well, first of all, your degree, as long as it is relevant, and it's a master's degree from an accredited school in USA, it makes you eligible for EB2 filing. It doesn't have to be a STEM. It can be a degree in arts, as long as it's related to your field. Okay. In fact, there are rulings on the books that say even unrelated master's degrees, as long as the master's degree is required for the job, can qualify you for EB2. So yes, you should qualify for EB2 if your job requires a master's degree. Invisible Joe wants to know, I have a bachelor's degree in STEM with 5.5 years of work experience in software. 3 years with the current employer. So questions are, if I apply through my current employer, can I apply for EB2? My profile has changed significantly. Yes. If the job offered and the job done so far with this employer are more than 50% different, you can use the experience gained with this employer. But mere change in technology is not change in job. Let me explain. You used to be a .NET developer. Now you are a Java developer. You're still a developer. That's not change in job. But if you went from being a developer to a system architect or a team leader or a project manager in such a way that the job that you will be doing is more than 50% qualitatively different, it's a different job, then you will be okay. Adding project management certification would help? No, it would not. I don't see how that would help. How hard is it to change from EB3 to EB2 at a later date? It's not hard as long as there is a genuine job offer for EB2 level job. If I decide to change my employer at a later date to be eligible for EB2, is it possible to keep the PD? Yes. You can keep your priority date even if you go from EB3 to EB2 with a different employer. Invisible Joe also had another question. Any estimate on what will happen to employment-based category if the new law passes? Definitely things will speed up. How far, it's difficult to say. I think EB2 for backed up countries like India would become a lot faster. EB3 will also become faster. What will happen to the rest of the world, I do not know. We still have to wait and see what happens with the actual number movement. Remember, a lot of these, what they are doing is not only are they taking away per country quota, they are creating quota exempt categories as well. Okay, so it's difficult to predict how it will all be affected, but definitely things will become faster. There's no question about that. Slick Deals wants to know, EB2 or EB3? 6 years expiring November 2013. Possible extension of 1 month. Company is going to file under EB2. Is 6 months time sufficient for getting permanent I-140 approved? I don't know. Depends. If you're lucky, sure. If not, who knows? If I go back to India in November and then my permanent I-140 is approved in Feb, can I extend and come back on the same H-1B? Yes. You become subject to the quota only if you have been physically outside the United States for 1 year. Which is safer and faster option, EB2 or EB3? I'm talking in terms of audit or perm. Look, if you are talking about only audit, usually if your job is EB3 level, actually more than that, if it meets something called SVP. For most IT jobs, that means bachelor's plus 2 years or less. And that's an EB3 job. Your chances of audits are reduced. Personally, I have done very few EB3s in the last few years. Most of our cases are EB2 filings. They are senior level people or who've been around for a long time. So we are doing EB2 cases mostly. And I personally don't find them to be very difficult either. Audit is not the end of the world. Okay. So, but if you're asking a little bit safer perm, if the job is BS plus 2 or less, maybe a little bit safer. Just a question wants to know, 485 was filed in Jan 2012, changed jobs in November 2012. They need an employment verification letter. It should include minimum education or training required. Perm says masters plus 2. Employer says their position requires bachelor's. Is it mandatory to include education and training in the letter? And the answer is, I would say yes, because that's what the government has asked for. Okay. So it is mandatory. Second question is, my spouse also got a similar RFE, although she's a dependent. Shall we just send a clarification letter? Absolutely. What is happening is USCIS is just sending out blindly all these notices without worrying whether it's really applicable to the situation or not. Okay. So yeah, you can give a clarification. Lincoln 123 got an I-94 which was of shorter duration than what he should have gotten. Is it my imagination? Time went through very quickly today. Wow. I must have talked a lot. It's almost 1:15 already. But I'll do my best to accommodate everybody's questions. Okay, no worries. So the question is, I have an H4, I-94 is valid till August of this year because the old passport was expiring. Can I visit CBP? I need to get an I-94. Can I visit CBP officer and will they extend it? Probably not. If you still have a visa stamp, they will give you, if you leave USA and come back using that visa, they'll give you, because you have a visa stamp till 2015. So if you leave USA and re-enter, you should get I-94 till 2015. You can try going to CBP office, see if they will take care of this for you. I doubt it very much. Last question is from Vivian Iber. Sister got deported. Again, 212A7A11. It looks like a misrepresentation. I don't remember off the top of my head. Oh yes, because she had some evidence that showed that she was entering. Oh, okay. The problem is there are two grounds, different grounds. She got under, that's not 212A7A11. I'm going to have to look up the law. I don't know the answer top of my head. I don't know all the sections of law off the top of my head. So what you're trying to do is, if she's been outside for 5 years, she's no longer, no longer needs I-601. I don't know how to answer that question. Here's what you should do, Vivian. You should have a consultation with a lawyer. Let them review your paperwork. Okay. I don't know what grounds were applied to her, what 212A7A11 means. Off the top of my head, I don't know the answer to that question. What does 212A6C mean? Somebody has to look up the law for you and do a one-on-one consultation. Okay? Only then that question can be answered. I don't have the answer for you. I'm sorry. Okay? That said, anybody who has a follow-up question, that just ends our questions as they are written down. Anybody who has a follow-up question, press *5 on your telephone. *5. Press *5. 2 people. Good. Okay. I'm starting in the order in which you logged in. 3 people. Okay. Now remember, this is not for new questions. It's only for follow-ups. We'll come to new questions next. So let's start with area code 781. Go ahead, please. Area code 781. Go ahead.
Hi, this is Rampis. My question number is number 5 on the list, and it was number 4. My question is, when I go to Canada for stamping, and Mr. took my case under RFE, they gave me RFE, and I still have my passport while they're doing investigation. Can I come back with valid I-94?
If I remember correctly, AVR is not available to people who have applied for a visa. You can double check that, but in my view, you should not be able to come back. Just double check that. Just type in a search engine automatic visa revalidation. It will bring you to the State Department page where they tell you what the law is. And I think if you have applied for H1 visa, you cannot use AVR.
No, I cannot.
No.
Even though if it's an RFE and it's not denied.
Yeah, I think it goes by application, not by denial.
Okay.
Okay, good luck.
Thank you.
Okay, let's go on to the next one. Area code 571. Pranam, how are you, ma'am? Hello?
Yes.
Ajiji, I recognize you. How are you?
Oh, I'm doing fine. This is Nita Vishwa calling.
Of course.
I just want to let you know it is not related to.
Just 1 second. I'm sorry. I think I disconnected my speakers. 1 second, please. Go ahead, Mitaji. I'm sorry. I disconnected my speakers. Please go ahead.
Yes. My question is related to the, for my elderly mom getting the birth certificate. I did go through your website, and I seem to be having problems. She's already 81, over 81. She has only one older brother, almost 90, in West Bengal, and I'm not sure. I think I can get a, like a waiver from.
Mitaji, this is not something I want to discuss right now. I'm only doing follow-up questions right now. Email me your telephone number. I'll give you a call tomorrow. Okay?
Okay, sure.
Yeah, email me. Yeah, email me your phone number. I'll give you a call tomorrow morning. You are in California, right? You are in California, right?
Right now I'm stationed in St. Louis.
Okay, it's good. So I can call you, or you can call me tomorrow morning. Just call me at 703-908-4800. My extension is 110. Okay, and best time to call me is before 8 a.m.
Before 8 a.m. your time?
Yes.
Eastern time?
Yes, ma'am.
Okay.
I'll talk to you tomorrow. Okay. All right.
Okay, then.
All right. Bye bye.
Okay, sure.
Okay, I think we have last question, one more question, then we'll start with new questions. Area code 925, go ahead please.
Hello Rajesh, this is Reddy. This is related to my second question, that is AC21.
Which question number, sir?
Second question.
Question number 2, okay.
Finally 2013.
Question number 2. Oh yeah, it's number 3 actually. Okay.
Question number
Oh yes, of course. Now I know your case. The pre-adjudication case. Yeah, go ahead, please.
Yeah. Um, His job responsibilities are the same, even the ones we specified in the labor and the new position, they are same, almost the same, or similar, 90% they are matching. Um, Other than that, the only requirement is like just specified as a master's plus 1 year, and the new job is bachelor's plus 8 years experience. So can I go ahead and take it?
You want my guess? Because that's the best I can do.
Hello?
I said you want my guess because that's the best I can do. There is no mathematical calculation here that I can give you.
Okay.
My guess is you should be fine, but I really want you to talk to your lawyers. I don't want to make that call for you. Okay? Personally, I think, remember, the criteria are same or similar. Okay? So, by USCIS standards, if you look at it this way, and remember, immigration law is never simple. It's just idiotically complicated. I mean, this is so complicated, it makes your head spin. First of all, the requirements of the Department of Labor and USCIS are different. So if you ask me, what is equivalent to Masters plus 1 according to Department of Labor, the answer would be Bachelor's plus 3. Okay. If you ask me, what is equivalent to Masters plus 1 by USCIS standards, my answer would be Bachelor's plus 6. Okay. So if we take the USCIS standard, BS plus 6 should be equivalent to Masters. BS plus 6 should be equivalent to Masters plus 1. So that's same. And if you have Bachelor's plus 8, that's similar to Masters plus 1. So same or similar. I would apply that analysis, but I don't want to make that call simply because I am not handling the case. I would want your lawyers to sit down with you and figure out what is the best thing for you. But I gave you my guess. I think you'll be fine.
So you suggest to file AC-21 or just to wait if there is an RFP, then file AC-21?
Judgment call, lawyer judgment call, depends upon a bunch of different things. My general rule is, I'm not commenting about you, but my general rule is, if I have serious doubt about the application, I don't want to file AC-21. Okay? Good luck. Alright guys, I'm open to any new questions. Anybody has any question whatsoever, press 5 star. Oh, did I say 5 star? Star 5, sorry. Press star 5. One question. Anybody who has any question, new, old, anything. Oh great. I'll be able to finish on time. Alrighty. One hand only. Area code 814. Go ahead please, sir or ma'am.
Yeah, hi, good morning. Good afternoon. My name is Gopi, and I know I'm on H1 right now, and I applied green card for EB3, and I have got approved I-140.
Okay.
But honestly, my real estate is 2007.
Sure.
So I want to see if I can port it to EB2. I have a master's in public administration. I have a postgraduate diploma in computers, and I have my O-level in Department of Electronics from India.
Okay.
I want to see if I'm eligible for EB2 posting.
Okay, let's look at your degrees one more time. Are you first of all working in the IT field?
Yeah, I'm in IT. I'm in US for the past 13 years.
Okay, hang on. Now, please answer my questions precisely. I need some information to help you decide. So you are in the IT field. Are you working? Do you have anything to do with healthcare?
Yes.
So you do software that deals with healthcare?
Yeah, I'm in insurance. Yes, yeah.
Okay,
Insurance.
good. So it appears that even the MPH could be related to your job, correct?
Sorry?
The Masters in Public Health degree could be related to your job, correct?
Public administration, actually. And this is in arts, and I can say Master of Arts.
Okay. Is it from an accredited university in USA?
Osman University, Hyderabad.
I don't know what that is. You have to figure out, first of all, is the degree accredited? I have a video on my blog on how to find out if a degree is accredited. Okay. Do an advanced search on my blog on accredit or accreditation. You should be able to pull up the video. Now, okay, so we've got the MA. Now let's look at your degrees. You have your first degrees from India or England?
I have everything in arts. I have a bachelor's in arts and a master's in arts, and I did my postgraduate diploma, the 1.5 year diploma from one of the institutions in India.
Okay.
And I did my O-level exams, conducted by Government of India Department of Electronics. I have the certificates of that.
Okay. Hang on. Again, stop. I just need degrees right now. So BA, MA, 3 plus 2? Okay. Was the BA after 12th grade?
Yeah.
Okay. And what were your subjects in MA?
Public administration, political science, and sociology.
What kind of software are you developing?
I'm totally in Oracle, all Oracle related, Oracle Financial, order to cash.
So you're doing ERP development.
ERP, yes. ERP and PSC for technical, yeah.
Okay. Theoretically, at least, I think you can go for EB2. I have to know a lot more. Your lawyer should help you decide that. But as far as just a raw assessment is concerned, you said you have 13 years of experience. I think you should be able to qualify for EB2. Yes, sir.
Okay. Because my lawyer was saying, it's not possible for me, so I just had,
Well, I look at it. This is the way I look at it. One, you have 5+ years of experience, and you have a bachelor's degree equivalent because you've got a 3+2 combo. 2, you also have a master's degree. Now, even though it is not directly related to what you do, if your job requires a master's degree in any discipline, you could qualify for EB2. In my view, it certainly is at least theoretically possible. Okay? Anything else I can help
So
you?
in that case, I just have one small thing.
Sure.
In that case, if I come to you, can you handle this case? Can you handle
Wait, sir. I'm not trying to. First of all, let me clarify a couple of things. I'm not trying to drum up business here. I don't want to take cases away from your lawyers. But hang on. Let me explain something to you. The way we work is, I will need to talk with your employers. You may be better off doing a consultation with us first, so that I can assess with your employer whether they have a job that qualifies for EB2, rather than retaining us, paying us all the money, and then finding out we can't really do it, and then your money is gone. Well, or your employer's money is gone. So, may want to do a consultation with us. I'll take a look at the case. I'll talk to the employer. I'll see what their standard job requirements are. That certainly is possible. In my view, theoretically at least, it's possible to do an EB2. Yes, we'll be happy to do it for you. Okay?
Okay, thank you.
Oh, you're welcome. All right, folks, it does not look like anybody has any other questions. Once again, *5 if you have a question. Oh, one more. Okay. All right, this will be the last question I'll answer today. Go ahead. You raised your hand. What is your question?
Hi, Rajiv. I applied IIT for my spouse, and it's documentally completed and at NBC, and the project is January 2005. My question is, they're saying that the dates will be open and become current in only my date, August, September. In this scenario, so just worried, will my spouse get an interview by this time, or if not, if it goes to October, then date might retrograde. So I just want to know your opinion how NBC works.
I-824 is not yet approved, right? It's still pending.
It's approved, and all the documents were submitted to NBC. The case is documentally completed. They're waiting for visa.
It's going to be close. I cannot really tell you one way or the other. It's definitely going to be close. What you can do is you can contact NVC. You said the 824 has gone through. Have they sent you the forms from NVC? Have you supplied them back those forms?
Yeah, I supplied the form. I have provided all the civil documents, and they said that our case is documentary complete, and they're just waiting for the visa.
Okay. Have they sent the case to the consulate?
No, they haven't said. It's still at NBC.
Okay. Okay. All you can do
They are
is
saying once the
Yeah.
dates are current, once the priority date becomes current, they are going to schedule an interview and send it. So,
okay. Well, as soon as the priority dates show up current, you should contact NVC, make sure they move on it.
okay.
There is some chance it might you might be able to make it in that time frame, but it's impossible for anybody to predict.
So what if that if I'm not able to make up and the dates retrograde, and what will happen?
You will get your green card. She will have to wait. Then you will apply. You should also apply for her green card separately using I-130. Do both.
Yeah, I already have my visa, but I'm still followed to join.
But why don't you also file I-130 for her? It's a good idea to do both.
No, but it's too late, right? I already been closed. I did not know that the date fit retrograde. But if I file I-130, it will take several years again. So I am already gone through this process.
Okay, well, I really can't predict how it's going to work. If the priority date slips back, she's definitely not going to get following to join.
No, but when the dates current, so how 485 people will get up? They can approve it faster, or for consular processing they assign a visa and schedule an interview later. Or
Wait. Listen to me. The law is on the date her immigrant visa is approved, priority dates must be current.
Okay.
When you do it through 485, it's done here. If there is no interview, no problem. They get their green card right away. When you are doing it through India, they still have to schedule you. They have to have you go for medicals, then schedule you for an interview. If the priority date slip back during that time, you're out of luck. We've had cases where one day before the interview, the priority date slipped back. You have to wait. Okay.
So even if they go until they go for the interview, the priority date has to be current, or when they attend interview, it's done like a
priority date. If it is not current, they will not be interviewed.
Okay.
Okay. I gotta go. Listen, I don't have anything else to add to the information I've already given you. Listen, there's one more call I've got to take. Guys, I really have to run. I'm a little bit out of time. So let me go on to the last call. I won't be doing any more calls. Please don't raise your hands. Go ahead, please. Area code 973. Go ahead.
Rajiv, this is Kumar. Question. I have EB3 of 2003 application pending, ported to EB2, and 180 days passed. I want to know that AC21 can be done for the EB2 case or not.
Okay. Let's look at when was the I-140 for the EB2 approved?
About 1 year back.
For the EB2?
Yes.
And you basically took...
EB3 priority date is 2003.
Okay. You basically interfiled that I-140 on top of the I-40. You couldn't have because the priority dates are not current, right? Yeah.
You mean interfiling, whether it is complete?
Yeah, they will not accept interfiling if the priority date is not current, correct? I think that's the way it works. Yeah, I think that's the way it works. I'll have to ask somebody in my office who does these cases. A bunch of people do them. What the government stand on this thing is, but I think, and I could be wrong about this, double check this. I think that they will not accept interfiling until the EB2 priority date is current. And if interfiling is not accepted, then your AC21 for the EB2 is not yet activated. You can only do EB3 porting. That's what it looks like to me.
Okay. Got it. Thank you very much, sir.
You're welcome. Good luck, sir.
Bye.
Thank you, everyone. I'll see you in 2 weeks, next Thursday. Bye-bye.